Hi everyone, happy Friday. I am Lillian Chukura. I am the attorney and owner of Lily Legal, where we help our clients get status for themselves and their families using the U.S. immigration law system. So today I want to talk to you about the three ways your previous marriage can affect your current marriage based immigration case. I love talking about this topic. I get so many questions. I see this come up a lot with some of my clients. So I thought I would just spend the time, talk to you about it, and make sure you avoid these mistakes because they can be brutal for you to overcome. So let's make sure that you know what these top three things are so that you are not making the same mistakes. Okay. So now, if you want to schedule a private consultation with me, you can do that by going to my website, lilylegal.com, or by calling my office at 508-443-1788. As always, all my contact information will be in the description to this video. So let's jump right in because this, like I said, this is a topic that I love talking about. I love when people are ready to start their process and we can basically check these three things off and make sure that it is not going to be an issue in their case. Okay. So the first thing is applying for a visa and not including that you are married, right? So if you're applying for a visa to the US, there's this myth that if you put that you're married, that you would not get the visa. And the opposite is also true, where people believe that if you're not married, that you would not get a visiting visa to the US. And for that reason, they leave off the fact that they're either married or they're not married. Right. So, in both of those situations, it can come back and haunt you. Okay. So, first off, if you say that you are married when you are actually not married, that is misrepresentation. That is going to hunt you when you go to apply through your now current spouse. Okay. So, if you're married to a US citizen and you're ready to file, you need to remember what you put on your visa application when you are coming to the US. Again, this is if you're physically in the US. And even if you're not in the US, this applies to you because if you have ever applied for any visa to the US and you have put in there that you're either married when you're not, right? Or that you're not married when you actually are, both of those situations is misrepresentation. Okay. And the US government can require you, in most situations, they will require you to file a waiver for that misrepresentation. So, when you're filing with your spouse, the first thing you need to do is remember every single visa application you have ever filed, even if it didn't lead to you being able to come to the US, right? Even if you filed the application and the visa was denied, that can still come back. Okay. Just keep that in mind. If you file a visa application, even if the visa application is ultimately denied, it can still come back and affect your current marriage based green card case. Okay. Remember, and I say this all the time, and some people do not believe me, you have one immigration file. US government has at this point updated their system to the point that they don't actually use physical forms anymore. Okay. Physical files. So they can send the file over to the embassy without having to physically mail documents. They can email it. They have their whole system on how to share documents between the State Department and USCIS. Okay. So whether you're applying outside of the US or in the US for a green card through marriage, a green card period, if you have misrepresented information about your marital status, know that it is going to come back and you should be preparing yourself One, if you're working with a lawyer, you should be informing your lawyer so they can best advise you on what you actually qualify for. Most of the time, it would be a waiver. But again, it depends on what you're applying for. Okay. So just keep that in mind. If you ever filed a visa application and you said that you were married or that you weren't married when the opposite was true, that's going to haunt you. That's going to affect your current marriage based green card application. And it's going to lead to either the embassy or the USCIS saying that you need a waiver to basically ask the government to forgive you for lying about your marital status. And in some situations, they will frame it as, oh, well, you filed a visa application, you know, in 2002 saying that you were married, give us a divorce certificate for that marriage. And some people, instead of admitting that they were never married and just apply for a waiver, would instead go and get a fake divorce decree, which once the US government finds out that it's fake, it's even an additional layer of misrepresentation because now you're presenting false documentation on top of the false statement that you made. So just keep that in mind. You want to make sure if you're currently applying for a visa or if you've applied for a visa in the past that you know what's in your application before you start so that you can prepare yourself in case it leads to you needing a waiver. Okay, so that's the first thing. The second thing is not properly ending your previous marriage. Now, what does that mean? In order for your current marriage to be considered valid in the US, if you have ever been married before, you're expected to have a termination of your prior marriage. So that means you either have a divorce decree, an annulment, or a death. So if your spouse passed away, you need the death certificate. If you got divorced, you need the divorce decree. Okay. And something to keep in mind, just keep this in mind. In some countries, you have traditional marriages, right? Customary marriage. And people assume that customary marriages do not count because you're not going to the courthouse or registry to register your marriage. However, for US immigration purposes, because they have um, staff in all these countries, they know the countries that customary marriages are the same as a regular traditional marriage in the Eurocentric sense of the word marriage, right? So they know the difference. And if you tell them that, oh, you're not married, you just, it was a customary thing, it doesn't count for US immigration purposes, it counts. Okay? It counts as a marriage, and that marriage needs to end before you can get married to someone else. That's that's the bottom line. Before you can move on and marry someone else, that initial marriage, whether it was customary or you went to a church registry, courthouse, whatever it was to get married, it must have ended. Now people will say, well, a customary marriage, for example, in Nigeria, to end a customary marriage, the wife's family will give back the bride price, and the families just agree that the marriage is over, and people will stop there and think that's enough or get an affidavit stating that. Well, now, um, there is a mechanism in most of these countries. Again, I'm using Nigeria as an example, but also in Ghana, I know for sure there is a mechanism to go to the court once your family have agreed that the marriage has ended and the bride price, whatever the traditional customary thing is to end the marriage, once that has been concluded, you can actually go to the court and register that dissolution of your customary marriage. Okay, so you can let the court know, hey, by the way, we were married, now we're no longer married. And you want to do that as soon as possible after the actual customary things are concluded. Okay, so just keep that in mind. Even if it's a customary marriage, even if it's a customary divorce, the US government still wants proof that that divorce happened. And in most countries now, there is a mechanism to do it through the court. And you should be registering your customary divorce through the court so that you have documentation of when it took place, so that the US government can look at the divorce decree from the court for your customary marriage and see that that took place before you married your current spouse. It is so important and it makes such a difference. So, let's say the customary divorce took place 10 years ago and you just registered it with the court 2 years ago or last year, even. USCIS is going to question um, the timeline because they're going to be looking at, did you actually get divorced when you said that you got divorced and you're just, registering it now? Or is that really when you, is the date of the registration when you actually got divorced? Okay, so you want to make sure that if you are doing a customary divorce, that you are also registering that with the court. Again, some countries are different, and it's not even possible to register a customary divorce in certain countries. But I can tell you um, from experience, in most West African countries, you can and you should register the customary divorce. Again, I'll keep saying this. A customary marriage counts as marriage for US purposes. Okay? For immigration purposes, a customary marriage counts. So keep that in mind when you're filing, because that can come back and hunt you if you said that you were never married, um, or you put in one of your visa applications that you were married and then you had a customary divorce, and now you're telling the US government that you're not married because you got that divorce. However, if you don't have documentation to prove that you actually did get divorced, that's going to hunt you. That's going to make it hard for you to get a visa, to get a green card through your current spouse, because now the US government is going to question whether you're actually divorced, whether your current marriage is valid and legal, right? Because US does not support polygamy, bigamy, none of it. It does not support it. So if you are married to more than one person at the same time, it's going to be an issue, and one of the marriages need a divorce. And in certain situations, you need to not only divorce the prior spouse, but you have to remarry the current spouse for it to count. So keep that in mind. So that's the second way your prior marriage can affect your current marriage based immigration case. Now, the third way, which is the worst way, which is one of the ways that cannot be fixed, is if you entered into a prior marriage and that spouse filed for you to get a green card, and the US government says, hey, we think your marriage is fraud. We think you only married this person so that you can get a green card. Or, oh, we think you paid this person to marry you so that you can get a green card. And if they can produce evidence of that, there is a ban on you being able to get a green card. Even if your current marriage is legal, even if your current marriage is real, even if you two are in love and have kids, and yeah, that prior marriage where you married someone just to get immigration benefits, that does not go away. And that will affect every single marriage based case you have in the future, because you would always have to not only prove that your current marriage is real, right? But you also have to prove that your previous marriage is real. So that really makes it hard for you to be able to get a green card through your now current spouse because of that finding from USCIS or the embassy that your marriage was fraudulent. There are, like I said, there's ways around it, but you need to know what you're walking into. So I've had clients where that was an issue and we were able to overcome it by, of course, presenting evidence that the marriage was real, that, you know, whatever statements were made, whatever it was, that it was a misunderstanding, and actually providing concrete documentation of the relationship and statements from both sides, proving that the marriage is real. It's still up to the US government whether they believe you or not, right? They have some evidence that they're basing their decision on, and you have to present documentation. The burden is on you to prove that that prior marriage was real. You entered into it in good faith, not for immigration benefits, not for any benefits other than the fact that you want to be with this person, you want to build a life with that person, and it just didn't work out. And it's okay if it just didn't work out, but they still want proof that there was a relationship there and it wasn't just for you to get a green card. Now, some people will say, well, if you're marrying a US citizen and you don't have documentation, wouldn't it always be that, you know, part of the reason for the marriage is that, you know, they will file for you to get a green card? Well, yes, there's always that underlying thing where your spouse would want to file for you, but US immigration is looking at, is this the only reason that you two got married? Right? Is this the absolutely only reason? Was there a relationship there? Was there anything else between the two of you other than the fact that you want a green card and this person happens to be a US citizen and they can provide that for you, right? And if there was any payments made, definitely that is a fraud, and the US government is going to look at it that way. So, by payment made, if you paid someone to marry you and file for you, clearly that's like a very clear example of a situation where it's going to be hard for you to prove that the marriage was real. Okay. If your prior spouse, if your prior spouse is no longer um, willing to present documentation of your relationship, or your prior spouse is the one that told USCIS that the marriage was fraudulent, it's going to be really hard for you to prove otherwise. So you really want to make sure that before you start a marriage-based case with anyone, that you have done your part to make sure the you know that you're following the US laws, especially the ones that say you cannot marry someone just so you can get immigration benefits, because that has consequences forever. Okay, that has consequences for marriage based cases and non marriage based cases. So I've seen this affect not just marriage based cases, but also if there's, for example, the Liberian Green Card Act, they will frame it as fraud. You you perpetrated fraud in order to get immigration benefits. Now prove to us that that was not a fraudulent marriage, right? You can still get it, but you need to present documentation to prove to us that you actually um, did the right thing, right? So, no matter what type of visa you're applying for, if you have had a prior marriage that the US government considered to be fraudulent, it will always come back and hunt you unless you were able to overcome it. And this applies to, even if you get your if you're applying for citizenship and you had a prior marriage and it becomes an issue, it can come back and hunt you. But specifically, you cannot get a green card through another spouse if you had a fraudulent marriage, point blank. And there's no waiver for this. And that's what people always want to know. Is there a way for me to get over this hump? Is there a waiver for it? There's no waiver for it. Okay. If they specifically said marriage fraud and not just like fraud misrepresentation, if it says marriage fraud under 204C, there's no waiver for that. That means even if you're good, you have the possibility of ending up in immigration court and, you know, the US government trying to remove you from the country. So it is so important that before you start your case that you are discussing any prior marriages, disclosing all prior marriages. You do not want to leave anything out because of course if once the officer finds out that you left something out, it becomes a question of whether it was misrepresentation or not, right? Because if it was misrepresentation, the officer can deny your case based on the misrepresentation and call it a day. And then you wouldn't get your green card. So it's so important that you disclose all your marriages, that you actually get divorced and register the divorce, even if it's a customary marriage, in the proper way in your country. Again, that's if you're not getting divorced in the US, right? If you're not getting divorced in the US, whatever way that is the legal way to get divorced in your country, that you are following that process, especially if it's a customary marriage. And then the first thing to keep in mind is if you have ever applied for a US visa and you put that you were married when you weren't, or you put that you weren't married when you actually are married, know that that's going to come back and that's going to present as misrepresentation or fraud that's going to need a waiver. And you want to know that before you start because that's going to affect your whole process. So you really want to know, okay, these are the things that can be an issue in this case, and how do we solve it, or how, what's the process to making sure you still get a green card at the end of the day, right? So not disclosing these things, especially if you're working with a lawyer, is a problem. Okay. It's a huge problem because it will set you back. And in some situations, it makes it impossible for you to get a green card. So you really, really want to pay attention to this and make sure you are aware of these three things. You know, these three ways your prior marriage can affect your green card based on marriage. All right. So that is all I have for you today. If you have any questions, as always, put them in the comments. I do go back and look at those. If you would like to schedule a private consultation with me, you can do that. All my links and number are in the description to this video. If you like this video, go ahead and hit the like button. And if you know someone that needs to hear this, go ahead and share this video with them. And if you are watching in a place where you can subscribe, go ahead and hit the subscribe button. And once again, I am Lillian Chukura. I am the owner of Lily Legal, where we do immigration law and we do it well. Bye for now.